5 seconds to go. Start. Thus, it is stated that it is not necessary to be enrolled under the 1861 Act, but if one is invested with the same powers, that is, the powers for prevention and detection of crime, one will be a police officer. Stop. Then, the PMLA is distinguished from the 1962 Act, see Customs Act, 1872, Central Excise Act, 1944, and the CGST Act. Stop. The dissenting opinion of Subba Rao, Judge in Barkat Ram is also relied upon. Stop. Thereafter, it is stated that PMLA, being a purely penal statute, one needs to look at the statement of objects and reasons of the 1999 bill and the Financial Action Task Force recommendations. Stop. Para. Reliance was also placed on Raja Ram Jaiswal versus State of Bihar. Stop. Further, it has been stated that even in Tufan Singh versus State of Tamil Nadu, the case of Raja Ram Jaiswal has been relied upon, and it is concluded that when a person is vested with the powers of investigation, he is said to be a police officer, as he prevents and detects crime. Stop. Further, the powers under section 50 of the PMLA for the purpose of investigation are in consonance with what has been held in Tufan Singh and establishes a direct relationship with the prohibition under section 25 of the 1872 Act. Stop. Another crucial point raised is that most statutes where officers have not passed the muster of police officers in the eyes of law, contain the term inquiry in contrast with the term investigation used in section 50 of the PMLA. Stop. A parallel has also been drawn between the definition of investigation under the PMLA in section 21NA and section 2H of the CRPC. Stop. Further, it is asked that the test of power to file charge sheet is not determinative of being a police officer. Stop. Para. It is then asked that section 44(1)(b) of the PMLA stipulates that cognizance can be taken only on a complaint being made by the authority under the PMLA. Stop. Whereas, in originally enacted section 44(1)(b), both the conditions, that is, filing of a police report, as well as, a complaint made by an authority were covered. Stop. Learned Counsel also reminisces of the speech of the then Finance Minister on the Prevention of Money Laundering Amendment Bill, 2005 in the Lok Sabha on 6th May 2005. Stop. However, it was also conceded that the amendment of section 44(1)(b) of the PMLA removed the words, upon perusal of police report of the facts which constitute an offence under this act or. Stop. Next amendment made was insertion of section 45(1)(a) and section 73(2)(ua), by which the right of police officers to investigate the offence under section 3 was restricted unless authorized by the central government by way of a general or special authorization. Stop. Further amendment was deletion of section 45(1)(a) of the PMLA, making the offence of money laundering under the PMLA a non-cognizable offence. Stop.